Okay, good morning to our respected lecturer, Dr. Muharis, and our fellow classmates. Assalamualaikum warahmatullahi wabarakatuh. Today, we would like to present you our video project on the topic of contract law under the case of Syed Jaafar bin Syed Ibrahim v. Maju, Mehar, Singh Travel and Tours. I will give you a brief introduction and the facts of our chosen case. My groupmate, Adeline, will speak to you about the issues and the holding of the case. Last but not least, Khor Kai Boon will continue in the issue of the case and the rationale of the holding. Okay, hello, my name is Alifah Ilyana, 2800423. So for my part is, what is a contract? A contract can be defined as a type of agreement where there is an exchange of legally enforceable promises between parties. To create a legally binding contract, there must be 6 essential elements. The first one is there must be an offer where one party is willing to enter into an agreement with another party. The second one, there must be an acceptance where one party signifies their willingness to enter into a contract with the party making the offer. The third one, an offer can be accepted by words or actions. The fourth one, there must be consideration given by each party. The next one, parties to a contract must intend for the agreement to become binding when it is accepted by the other party. And the last one is, there must be certainty of terms between the parties to the contract. Okay, so for the next part is, what does a contract look like? A contract is often in the form of a written agreement between parties. Contracts can also be in the form of an oral agreement, but oral agreements can be much harder to prove when a dispute arises. In our presentation, the contract case that we will highlight is Syed Jaafar bin Syed Ibrahim v. Maju, Mehar, Singh Travel and Tours case on damages for breach of contract. So I pass to the next presenter. Okay, so the next part is the facts of the case. In the case of Syed Jaafar bin Syed Ibrahim v. Maju, Mehar, Singh Travel and Tours Lirian Berhad, the plaintiff, who is the farmer from Kota Baru, ventured to do a part-time business, perform the travel arrangement for the people in his village who planning to perform the Umrah and Hajj in Mecca. In other hands, the defendant was a travel agency in Kuala Lumpur. The plaintiff entered into an oral agreement with the defendant. The defendant would return air tickets for the Hajj, apply and obtain visa for the passengers, and pay a commission of 2,000 ringgit to the plaintiff for every passenger he brought, and collecting 5,500 ringgit per person. The plaintiff collected 151 passengers and obtains monies from them and handed them over to the defendant. The defendant later informed the 2 flight debts to plaintiff, and plaintiff then made arrangement for the departure of passengers from Kota Baru to Kuala Lumpur. He buys the return air ticket for them. The defendant could not obtain visas, and the plaintiff need to arrange the food and accommodations for the passengers. After the passengers returned to Kota Baru without performing the Hajj, the plaintiff claimed the amount of the cost from the defendant. However, the defendant denied to do so. The court held that the plaintiff and defendant intended to create a binding contract via oral agreement.
Hi and good day to all. My name is Adeline Anne and my matrix number is 281046. I'll be presenting the issue and the holdings of this case. The first issue is to create a binding contract orally. The plaintiff, a farmer from a village in Kota Baru, Kelantan, started a part-time company in which he made travel arrangement for people from his area who wished to undertake Umrah and Hajj in Mecca. During the trial, the defendant worked for a travel firm in Kuala Lumpur that catered to all places, including Jeddah, which is for Umrah and Hajj. According to the lawsuit, in December 1991, he met with DW1, which is the managing director of the defendant, and he verbally agreed that in exchange for the plaintiff sending passenger to the defendant and receive Rm 5,500 each individual, the defendant would give return air ticket for the Hajj. Among other things, apply for secure visas for travelers and also pay an Rm 200 commission to the plaintiff for each. The plaintiff had recruited 151 people to conduct the Hajj in May 1992 and had received Rm 830,500 from them, which he had turned over to the defendant. After he paid the defendant in full for 151 passengers, the managing director told him that they were scheduled to depart from Subang International Airport in two groups, which the first is 74 passengers on 11 May and 72 passengers on 18 May 1992. The plaintiff then agreed for these people to travel from Kelantan to Kuala Lumpur. He spent almost Rm 27,180 on round-trip airline tickets. For the next issue, I'll pass it to the next presenter.
Hello everyone, my name is Khor Kai Boon, metric number 278118. I will continue with the issue of the case. On 11 May 1992, the defendant noticed the plaintiff that they were unable to obtain visa for passengers, so they were unable to leave on scheduled flights. However, the defendant informed the plaintiff that the first group of passengers could depart with second group of passengers on 18 May 1992, when the defendant would obtain all visa. The plaintiff have to arrange accommodation and provide food for these passengers in Kuala Lumpur. On 18 May 1992, the second group arrived in Kuala Lumpur from Kota Baru. The defendant once again told the plaintiff that they could not obtain visa for passengers and all passengers could not leave on scheduled flights. The plaintiff once again has to arrange accommodation and food for the second group of passengers. All the passengers finally returns to Kota Baru on 5 June 1992. The plaintiff filed a claim against the defendant for the cost of Hajj air tickets and cost of bringing passengers from Kota Baru to Kuala Lumpur and cost of keeping passengers in Kuala Lumpur from 11 May to 5 June 1992.
Of the case, the court holds that all necessary elements to constitute oral agreement exist in this case. They are very simple. For an oral contract to be valid, it must have the three essential elements for an enforceable arrangement. First is an offer, second is the acceptance of an offer, and third is the consideration. If any of these elements is missing from an oral agreement, there is no legally binding agreement and therefore no enforceable contract. In this case, the plaintiff contended that the first defendant Mehar Singh orally agreed that the consideration of the plaintiff providing this passenger to the defendant and collect Rm 5,500 per person. The defendant would first issue written air tickets for the Hajj to Jeddah for this passenger. Second, he should apply the obtained visas for the passenger. Third, he should make agreement for the accommodation in Jeddah for this passenger. And lastly, he would pay commission Rm 200 for the plaintiff for every passenger he brought by him for the defendant. Moreover, the first defendant stated that he was registered agent who could make such arrangement, and for the plaintiff he agreed to said terms, and the plaintiff immediately submitted the monies and collected from 100% monies collected. Moreover, the first defendant stated that he was a registered agent who could make such arrangement for the plaintiff, and he agreed to said terms, and the plaintiff immediately submitted the money he collected from 100 persons together with their passport to the defendant. Defendant, on the other hand, denied that there was such an agreement between the plaintiff and itself, and contended that such agreement ought to have been reduced to written and seems to ignore the existence of oral contract. However, the court held that both plaintiff and defendant intended to create a binding contract, and there was an agreement between them as all the three essential elements for the oral contract to be valid were being fulfilled.
Next, I will continue with what is rationale of holding. The rationale of holding explains the court's holding and legal rules, known as court reasoning, explain why the court decide the outcome of the case. Potential components of the court reasoning include cases that have been tried, distinguished, and overturned before. Second is fact, which one are predisposed and which one are not. And third is statutory law and its interpretations. And last is principle of public policy. The rationale of holding. The court of rationale of Sheikh Jaafar vs. Maju Mehar Sim Travel and Tours Sendirian Berhad case. The plaintiff's claims a Rm 614,500 were rejected by the court because he did not show any evidence to support his claim. The court pointed out that the plaintiff needs to produce evidence that the passenger has not received the defendant's refund, and the plaintiff also needs to prove that the passenger has authorized the plaintiff to sue on their behalf, or the plaintiff to sue as a representative. However, the plaintiff must at least provide sufficient of satisfactory evidence to enable the court to make the fair and reasonable assumption about the loss.
Okay, so for the conclusion, based on the above case, although the law allows for a contract to be made orally, the issue with oral contract lies on the difficulties of proving the terms of the contract when there is a dispute, since parties normally have different recollection of what have been agreed between them. It is therefore strongly recommended for an oral contract to be immediately set in writing so that the express terms of the agreement can be outlined in the contract to avoid future misunderstanding or dispute between the parties. So that's all from us. Thank you.